Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, salam kebajikan dan salam sejahtera bagi kita semua. Good morning and welcome to all of the participants of today's public lecture organized by Center for Environmental Law and Climate Justice CELCJ FH UI in collaboration Swastiastu, Namo Buddhaya, salam kebajikan dan salam sejahtera bagi kita semua. Good morning and welcome to all of the participants of today's public lecture organized by Center for Environmental Law and Climate Justice CELCJ FH UI in collaboration Swastiastu, Namo Buddhaya, salam kebajikan dan salam sejahtera bagi kita semua. Good morning and welcome to all of the participants of today's public lecture organized by Center for Environmental Law and Climate Justice CELCJ FH UI in collaboration Swastiastu, Namo Buddhaya, salam kebajikan dan salam sejahtera bagi kita semua. Good morning and welcome to all of the participants of today's public lecture organized by Center for Environmental Law and Climate Justice CELCJ FH UI in collaboration Swastiastu. Good morning to all. Good morning and welcome to all of the participants of today's public lecture organized by Center for Environmental Law and Climate Justice CELCJ FH UI in collaboration with Indonesian Center for Environmental Law (ICEL) and Client Earth. I am Edmond Wang Triputra, serving as the Master of Ceremony today. I would like to welcome Your Honor Justice Nicola Pain, Land and Environment Court, New South Wales, Australia, as our speaker today. Thank you for coming today, Your Honor. Then I would like to welcome Mrs. Marsha Muhammad Handayani as the Head of Knowledge Management Unit, ICEL, and the Lecturer of Faculty of Law Universitas Indonesia. Thank you for coming here today, Mbak Marsha. I would like also to welcome all of the participants who attended our event today, both offline and online via Zoom crowd meeting. I hope that all of you are always in good health. It is truly an honor for us, the entire public lecture committee today, to be able to hold this event and be attended by such great speakers and moderators, along with the attendance of participants who certainly further support the course of today's event. The public lecture organized by CELCJ FH UI, ICEL, and Client Earth today raised the theme of the climate litigation development from Australia. To open our public lecture this morning, let us first hear a few words from the Vice Dean 1 of the Faculty of Law Universitas Indonesia, Profesor Muhammad Ramdan Andri Gunawan Wibisana, SH LLM PhD. For Prof. Andri, the floor is yours.
Thank you, Edmond. Good morning, Justice Nicola Pain. I'm very honored. We are very honored to have you here. And for your information, we have been offering the course on climate change law since 2015. So it has been around 8 years. And one of the subjects in the course that we put emphasis on is about climate litigation, and of course to have you here to share information about what's going on in Australia will be very beneficial for us as well. So as a lecturer, I ask students who take the course, climate change law course, and also all courses on environmental law related to environmental law, to attend to this session, and its obligation. So not only because it is very closely related to environmental issue, but also I believe that what you will share is very important as knowledge for us to further develop strategy in our efforts to enhance climate litigation in Indonesia and climate change law in general in Indonesia. So thank you very much. I hope we all have a good times here and a good discussion. And unfortunately, I cannot be with you because I'm in the middle of the meeting with the dean and the council of the professors of the faculty. So I'm so sorry, but again, thank you very much for coming and for and also for all of you, thank you for coming as well. That's it. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Prof. Andri, for your warmest welcome to all of us. With the opening remarks from Vice Dean 1 of the Faculty of Law Universitas Indonesia, the public lecture today has officially started. Therefore, let us move on to the material presentation session with our extraordinary speakers who have been with us today. However, before we begin today, allow me to introduce our excellent moderator today. Our moderator today is Mrs. Marsha Mutmaina Handayani SH LLM, better known as Miss Marsha. Mrs. Marsha obtained her Bachelor of Law degree from the Faculty of Law Universitas Indonesia and her Master of Law degree from the Faculty of Law, Lancaster University, England, with the focus on climate change laws and damage. Mrs. Marsha is active as one of the researchers of the Indonesian Center for Environmental Law, and she's also in charge as the head of redaction for Jurnal Hukum Lingkungan Indonesia. For Mrs. Marsha, the floor is yours.
All right. Thank you, Edmond. Good morning, everyone. I'm very pleased to meet you here and today's public lecture on climate litigation development from Australia. Before we move forward, please let me introduce our distinguished speakers who has been already with us, Justice Nicola Pain. Justice Nicola Pain, was appointed a judge of the Land and Environment Court of New South Wales in 2002. Early in her career, Justice Pain was director of the Environmental Defenders Office, a public interest community legal center based in New South Wales. Justice Pain also worked in environmental law and policy in senior positions in New South Wales and Australian government departments. Justice Pain is an adjunct professor and chair of the Australian Centre for Climate and Environmental Law Advisory Board at the University of Sydney Law School and was a visiting professor at the University College London and King's College London in 2002 and 2003. 2022 and 2023. She has presented and published numerous papers for a wide range of audiences in Australia and overseas on environmental and related topics. Before the lecture begins, let me inform how the presentation will be going. First, Justice Pain will be invited to present the material in 45 minutes. After that, there will be questions and answer sessions and followed by conclusions. Now allow me to welcome the speaker, Justice Nicola Pain, to deliver her presentation. You may have the floor.
Selamat pagi and greetings from Australia. I am sorry I cannot use Bahasa more and I will have to present in English. So I was asked to speak about climate change litigation in Australia, and as you'll be hearing from me, there is actually quite a lot of climate change litigation in Australia. Next. So what I'd like to cover today is to give you some context. So I'm going to give an extremely brief overview of environmental law in Australia and an introduction to the Land and Environment Court. That is the court on which I sit and have been for a while. And quite a lot of litigation related to climate change is happening in my court, but it is also happening in relation to other courts. So I think it's important to understand why that's happening in Australia. I've got quite a few cases to tell you about, possibly too many. We'll have to see how we go on time. One of the interesting things about environmental law litigation, including climate change litigation, is that it's extremely expert heavy. So how courts deal with expert evidence is one of the challenges for judges. So I thought it might be of interest to talk a bit about expert evidence and how we manage that in the Land and Environment Court, and make a few remarks about the challenges of scientific evidence in climate change cases, which for judges can be very challenging. Next. So, who administers environmental law in Australia? We have a very old constitution now, 1901, and that constitution was really trying to provide a blueprint for then the new states of Australia. We are a former British colony, and the national government. So in 1901, the idea of the environment and human rights did not exist. So unlike more modern constitutions, such as the Indonesian Constitution, the Australian Constitution doesn't say anything about the environment or human rights. And we're a bit unusual now around the world because of that. So that means that the majority of planning and environmental laws in Australia happen at the state level. So in my state of New South Wales, it has the most population, has the most development, and it has this unique specialist environmental court that I'll talk to you about shortly. So most of the case law is happening at those different states, 6 states in Australia at those state levels. As you'll be hearing though, because I'll be referring to it, there is a role for the Commonwealth Government on more major environmental planning assessment of things that might involve the World Heritage Sites, a Ramsar wetland, for example. So there's been litigation in Australia based about protection of the Great Barrier Reef, which is a Commonwealth-controlled area and is unfortunately being very much affected by warming sea temperatures, which increasingly is being accepted as a result of dangerous climate change caused by human activity. Next. So one of the interesting things about climate litigation is that in fact it's continuing to be considered in planning context, looking at particular proposals. But an expanding area now is looking at corporate law, so consumer, corporation and financial services law. So in Australia, that happens to be a power that was reserved to the government in 1901. So a couple of cases I'll talk to you about involve national consumer and corporations and financial services laws. And that's in a sense in Australia, the new area of climate change litigation that's happening. Next. Before I do that, I'd just like to tell you briefly about the history of the court, how it got established, and basically the sort of work we do. And I have an interesting photo to put up in the context of alternative dispute resolution. So in terms of a court, we look very much like any other court, I suspect, on the left, looking at that PowerPoint. Most of our hearings are in person, but we are a court that travels readily around New South Wales to look at sites. So I would regularly leave Sydney and travel somewhere else, as do my colleagues, to look at the actual site that we're considering. And that's a very important part of our process. Can we go back? Thanks. I just wanted to emphasise on the right that thanks to COVID, we also now do a lot more remote hearings. And actually, from an access to justice point of view, I think that's been very good. So now it is much more able to have experts appear from outside New South Wales and to have applicants. We have applicants who are community groups seeking to protect the environment, and they can attend remotely. So before, when you wanted to see a court in Australia, you had to physically turn up. Now you can get a link and watch online. I think that's been an excellent development. One of the few excellent developments that came out of COVID. So we've been going for about 43 years now. We are a Superior Court of Record, it's called, in New South Wales. In New South Wales, and I'll put up a slide shortly showing where we fit in the hierarchy. It means that we can fine or imprison for contempt of court. And what makes us pretty much unique in the world is that we have civil and criminal jurisdiction in defined areas. And apart from minor criminal offences, which are prosecuted in the local court, everything otherwise has to come to the Land and Environment Court. So that exclusive jurisdiction means that over that time, the court has, I think, established a seriously good reputation for being able to deal with complex environmental dispute resolution. So in terms of civil jurisdiction, this is, I guess, a diagram showing where we fit in. So in New South Wales, you'll see we're on the same line as the Supreme Court of New South Wales. And I realise, talking to people at the conference I'm here for, that our naming of courts is a bit different. So in some jurisdictions, the Supreme Court would be the most superior court. In Australia, our most superior court is the High Court of Australia. So in civil context, the Land and Environment Court If you're appealing from a decision of mine, you go to the New South Wales Court of Appeal. So in my state, that's the most senior court. And very occasionally, you might get leave to pursue a case in the High Court of Australia, but that doesn't happen very often. And you have to go back. Sorry. On the left, I put up the federal court system because I will be talking about federal court cases in the context of the corporations law that I've already mentioned. So the Federal Court of Australia is in the middle there, and it has an internal appeal mechanism. So from a single judge of the Federal Court of Australia, there's an appeal internally in the court to what's called a full bench, which is a bench of 3 judges. And if leave to appeal is obtained, you may end up in the High Court of Australia, but not too many matters do. And so we've now moved to the criminal jurisdiction of the court. And it looks broadly the same as the previous slide, except that you'll see we're now in the middle, in the Land and Environment Court. An appeal is to the New South Wales Court of Criminal Appeal, and that is generally where matters would stop. And one of the interesting things for me as a judge is I sit on appeals from the local court of New South Wales. So I said that more minor matters in criminal matters could be dealt with in the local court magistrate level, but there is provision to appeal to the Land and Environment Court from that. So who are we? At the moment, we have 7 judges, including the Chief Judge, who's in that photograph. And we have 9 full-time commissioners and 18 acting commissioners, and also, very importantly, our registry staff. Next. So there's an interesting point to be made about commissioners. We are a superior court, but we have non-judicial officers, and this is one of our strengths. You can see up there, I'm not going to read it out, the expertise of the commissioners, but a lot of them, some of them do have law degrees, but most do not. And they come with expertise in things like planning, ecology, architecture, engineering, hydrology. So a diverse range of expertise. And the benefit of that for the court is that the Chief Judge, when he allocates matters, can give matters which match the expertise of the commissioners. And on very complicated merits appeals, which I'll talk about shortly, that means a judge might sit with a commissioner to assist in analysing the evidence. And that's one of the strengths, I think, of us. Can you go back to the previous slide? Thank you. I'm not going to read that out, but that just gives you a flavour of the kinds of matters the court is dealing with. The ones I particularly mention are planning and development and heritage, and also increasingly water resource management. Australia is a very dry continent, and dealing with water is an increasing problem for us. Next. We have 8 classes of matters. I think I'll just stress that development appeals are the most numerous. Those are merits appeals. So the court stands in the shoes of the government decision maker, usually a local council, could be a state government decision, and the court itself decides whether or not a particular proposal should go ahead, and if it does go ahead, subject to what conditions. And that is probably the largest component of the court's work. The judges spend a lot of their time in Class 4, civil enforcement and judicial review, and also in Class 5 in criminal proceedings, and Class 6 and 7 deal with those appeals from the local court. So I suppose I should emphasise, because we are a former British colony, we are a common law system, but all the law I'm pretty much looking at is statute-based, and I spend a lot of my time in statutory construction. And in terms of the style of litigation, it means it's adversarial. So the parties before us, the person applying to seek whatever the relief sought from the court is, will have some sort of onus of proof. So when you're looking at expert evidence, it'll be in that particular context. Next. There's probably a bit too much detail on here, so I'll just focus on the last column, but this is all available if you're interested online in the Land and Environment Court. We have a very extensive website that tells you as much information as we can about what the court's up to. So this is drawn from the most recent annual, probably not the most recent, but one of the recent annual reports. But you can see there, I've emphasised the Class 1 merit appeals are the most numerous, and that's why there are more commissioners than judges, as that's what they spend their time in. And as I said, the judges spend a lot of their time in Class 4 and that's civil enforcement and judicial review, and Class 5, which are criminal matters. We do a lot of alternative dispute resolution as well. That's very important. Obviously, conciliation, mediation, and neutral evaluation are offered. And as part of that, the commissioners in particular, sometimes judges will go out on site and listen to objectors. And so I do like this photo on the left, which shows that somebody turned up wearing a koala suit to one of the court hearings. That doesn't happen every day, but it's a fairly cute photo, I think. And that is showing a commissioner actually hearing a matter. I think he's probably hearing for an expert on site in that. And there are obviously interested objectors or community members participating, and that's quite a common event. I think I've just moved past the slide saying climate change litigation in Australia. Yes, so next. So climate change litigation worldwide is, I'm not sure if booming's the word, but there certainly is a lot of it. And that is a comparison of numbers of cases where the US, as you can see, is far and away the most numerous. Interestingly, Australia is second by a long way, but we also, given we're a small jurisdiction, we only have relatively few people compared to places like Indonesia. We have quite a lot of cases. And so this is drawn from the Sabin Centre at Columbia University's database, and also the Grantham Institute at the London School of Economics. And now those two, they used to have separate databases, but fairly recently they're cooperating, which is a terrific facility. But it's interesting, the Melbourne University in Australia has also started a database focusing on Pacific and Australian cases. And in 2022, a database called Litigation was launched, which is focusing on looking at the Asian region. So there is quite a lot of interest in gathering that data, and it does, I think, help anybody, including judges, to be able to get a feel for what's happening around the world. So I've now got quite a few cases to work through, and I guess I'm trying to make different points about how the court's dealing with these things depending on the cause of action and the nature of the case. So the decisions I'm talking about first are occurring in state courts and tribunals. So some are in the Land and Environment Court and a couple are not. So to sort of set the scene, one of the first Australian cases, and as I've said there, according to the Grantham Institute, the first in the world, was a Greenpeace and Redbank Power Company case where the court was for the first time asked to consider climate change in the context of whether a coal-fired power station should be given consent, development approval. So as you can see from the year, it's 1994, and at this stage, things were probably only just starting to emerge for the general public and amongst the scientific community, probably more advanced about the issue of dangerous climate change. So you'll see this was an objector appeal. So Greenpeace got to be a party in the case, and they brought forward evidence that was trying to convince the judge that development approval should not be granted. So the judge always has to make their decision based on what is before them. So she did hold at the time and accepted that carbon emissions would increase, but the effects of those emissions were uncertain. And given the benefits of the development, approval should be granted. So that is one of the challenges for courts, is how to balance the need for development, which is important for economic development, with environmental impacts. So moving ahead 10 years to 2004, we have the Australian Conservation Foundation and Latrobe City Council. This is in a different state. This is in the state of Victoria, which has the Victorian Civil and Administrative Tribunal, VCAT, which hears those merits appeals that my court hears in New South Wales. And that was also a challenge dealing with a pollution-intensive power plant, which Victoria has a couple of. It was an interesting case because it's the first time that indirect greenhouse gas emissions of a coal mine were considered in a planning assessment. So once again, in terms of the evidence being put before the court, which it must consider, or in this case a tribunal, they were trying to weigh up whether or not approval should be given, and ultimately approval was given. Next. So then we move forward to 2019, a case in the Land and Environment Court of Gloucester Resources Limited. And this was an interesting case for a number of reasons, including the consideration of greenhouse gases. So interestingly, the Minister for Planning, through his department, had in fact refused consent for a new coal mine in a very scenic and beautiful part of New South Wales. And the miner was appealing against that somewhat unusual refusal of consent for a mine. New South Wales has quite a few coal mines. So this was the coal miner coming to the Land and Environment Court saying, on the basis of all these merits, and here's the evidence, we want you to give us development consent. So the court refused consent on a few grounds. One of them was the impact on the water aquifer. The mine was going to use a lot of water, and that was a scarce resource. It would clear a lot of habitat, and there was going to be substantial biodiversity loss. But also the court considered climate change impacts, and the court considered, in the context of all the matters before it, that that was another reason why the mine should be refused. And that was a major and continues to be a major decision. And I will come shortly to the kinds of evidence that the court had before it when it did that. Next. So those cases that I've just talked about are really about mitigation. How do you reduce or not have further greenhouse gases? So I'm now moving to adaptation. So this means how, in the context of this development, should we adapt for climate change impacts? And in New South Wales, that particularly means looking at coastal development. So I've put up a couple of recent cases. The first one's in the Land and Environment Court. The second one's in Western Australia at the Planning Commission. Essentially now in New South Wales and probably in most parts of Australia, if you have coastal development, then you will be certainly looking at sea level rise and its impacts. So in both these cases, they were involving large subdivisions on the coast, and in both cases, development consent was refused because it was considered, given the projection for sea level rise, which there was evidence about in the case, that development consent should not be granted. Next. So this was an interesting case that I happened to have. So on the left is the beach that used to look like that before a major, major storm. And now the beach looks like it does on the right. And as you can see, a very large seawall is being built to protect that property. And there's actually a big debate at the moment about whether seawalls are a good idea, but certainly in the absence of anything else, they will protect the property behind them. Inevitably, they will have a negative impact somewhere else on the coast. That's one of the problems with seawalls. Anyway, the decision I had to make was whether or not I should have a time limit on the development consent for a seawall. So in the past, when you gave development consent for a seawall, you would basically assume it would last in perpetuity. But the issue from the coastal engineer, from one coastal engineer's evidence was whether in fact there should be a timeline to assess the viability of that seawall, and the coastal engineer had chosen 60 years. So basically it was designed to last, he was fairly sure it would last 60 years, but perhaps with sea level rise, the seawall needed to be assessed after that. Not surprisingly, the homeowner didn't want that kind of condition, because it does mean that in 58 years, whoever owns the house has to go through a process to assess the viability of that seawall. So that's the first time the court has been asked to consider that issue and to impose that kind of limit, time limit, on a development consent. And I suppose it's worth commenting in that context, the kind of evidence I had before me were coastal engineers, and they basically agreed about the modelling. They looked at intergovernmental panel on climate change reports, and they used models to try and show, or they did show, what was expected might happen on this part of the New South Wales coast, but they disagreed about whether or not that 60-year limit was relevant. And one of the interesting things and disturbing things about sea level rise, it isn't uniform, so it will affect different parts of Australia differently. And it just so happens in my state, parts of that coast will be greatly affected. So those were some merit appeals. Can we go back, please? So I'm moving on now to a different context. This is once again in the Land and Environment Court, and this was a judicial review I did in the context of a planning law, and it was really to do with impact assessment. So I had to decide whether or not the relevant Department of Planning's requirements for assessment for a new coal mine should include an assessment for Scope 3 emissions. So when you look at things like coal mines, but anything that is greenhouse gas emission intensive, you will talk about Scope 1, 2, and 3 emissions. So Scope 1 emissions are what, if you've got a mine, what the mine actually produces as part of its processes. Scope 2 are those emissions which are sourced from the energy which the mine uses. And generally, those are accepted. You would normally assess those, or you did back then anyway. And Scope 3 are really what the mine impact is, and that is the burning of the coal, whether in Australia or overseas. And a lot of Australian coal does get burnt overseas, and therefore contributes to, well, no matter where you burn the coal, it will contribute to climate change impacts. But one of the issues was whether or not the miner should be required to review those Scope 3 emissions, which up till then had not been happening. So I essentially found that there was a sufficiently proximate link between this large reservoir of thermal coal, which would be burnt. That's what it was for, and climate change. And I held that the assessment should go, so it should include that Scope 3 emission. And look, in 2006, that felt like that was viewed as a major decision, but many years later, it would not be considered very remarkable. Next. This is another interesting judicial review context where a mining company had been refused. It's actually a South Korean mining company owned by the government, which was keen to have a reliable supply of coal for its power generation in South Korea. And so they had identified some land with very good coal reserves in an area of the Bylong Valley. And you can see from the photograph, it's a beautiful area to the northwest of Sydney in New South Wales. And anyway, the Independent Planning Commission had in fact refused consent on various bases, including the potential impact on climate change. So I had to consider whether or not the Independent Planning Commission had done their job in a legally correct way, including the way they had considered greenhouse gas emission assessments. I thought they had done the job correctly in a legal sense, and I dismissed the appeal by KEPCO, the miner, and that was appealed to the Court of Appeal, who also upheld my decision, and the leave to the High Court was refused, so that meant that the mine couldn't proceed. This just gives you some context for judicial review decisions, because they are not about the merits of the decision. You're not looking at whether the mine should or shouldn't go ahead for merit reasons. You're looking at whether or not the particular decision maker has done the job legally correctly in an administrative law sense. So in this context, the court dismissed the challenge to the Independent Planning Commission's grant of a large gas project, and in that context, the consent authority had not failed to consider climate change impacts, so it was not an unreasonable decision. Next. So look, I'm moving to the federal court context now, and this is judicial review once again in a planning law context where the national government did have a role in relation to the assessment of this mine. So you can see on the left a plan that we're looking at the state of Queensland in Australia, and it has a very large area with major resources in it called the Galilee Basin. And the Carmichael mine has been a very controversial proposal from an Indian company, the Adani company, which I think is a family-controlled company in India, and it wants a constant supply of coal for its power plants in India. So this was approved at this Queensland government level, but also had to be assessed at the Commonwealth level by the Minister for Environment. And so ultimately, the Australian Conservation Foundation, which is the main national conservation environment protection organisation in Australia, was trying to argue that the Minister for Environment hadn't done their job legally correctly. So one of the interesting things here is the federal court, the single judge found the minister did not commit an error of law in characterising Scope 3 emissions, those are the emissions from the burning of coal, as not a direct consequence of the mine, and therefore did not fail to properly consider the precautionary principle. And depending on the judge and the issue before you, those kind of calls may be different in various courts. And that decision was upheld on appeal. The actual Carmichael mine was probably subject to about 7 or 8 different court challenges, but at this stage it is proceeding. Next. This is an interesting decision that's fairly recent, 2022. So what's increasingly happening, I think, in Australia is that First Nations, Indigenous people are becoming very concerned about the impacts of climate change on their ancestral lands. It is getting so hot in some parts of Australia that there is concern about how habitable it's going to be for people who live remotely. A lot of Indigenous people in Australia live remotely. So we're now seeing a bit more litigation where I think Indigenous groups, First Nations, are concerned about what is happening to them, and therefore what is the impact about climate change and what should they do about it. So in this context, Santos, which is a very large gas company in Australia, it's a worldwide company, they had a very large project in the Barossa gas fields off the coast of the Northern Territory. So that's to the north of Australia. And an entity called NOPSEMA, a terrible acronym, the National Offshore Petroleum Safety and Environmental Management Authority, had given consent for some, I think it was exploratory drilling for Santos. So this is the first time I think there's been this kind of challenge to that kind of approval, and essentially Mr. Tipa Kalipa, who was representing his First Nations community, was arguing that they had not been satisfactorily or, I think, consulted at all under the statutory scheme. And so the judge held that, in fact, the right kind of consultation hadn't happened, and that at the moment the whole process has had to be gone through again in relation to consultation. And I think for me as a judge, it's interesting, it had an on-country hearing. Could I go to the next PowerPoint? And this meant that the judge went out to this remote area, that's the Northern Territory, looking out to the Barossa valleys, the Barossa Sea, and the judge was welcomed to country in a traditional way and was basically told things about the culture up there through traditional cultural practices. And I think that's a really terrific development, and I would love to have been the judge on that case. It would have been so interesting to see that. Next. The next couple of examples are just to show you how diverse issues can be. So this is back in the Land and Environment Court. You may or may not be aware that in the summer of 2019-2020, Australia had appalling fires like we have never seen before. It was really appalling in and around. A lot of New South Wales burnt very badly. So one of the groups that was developed, that formed after that, was the Bushfire Survivors for Climate Action Group. So they took action in the Land and Environment Court to argue that the main environmental regulator in New South Wales had failed in its duty under its relevant statute to develop environmental quality objectives, guidelines and policies to ensure environmental protection from climate change. So the agency did come along and say, we think we have got that, but the court wasn't convinced that they did. And so the agency has been ordered to produce that kind of policy guideline and objective, and that resulted in January this year in the Environment Protection Authority's climate change policy being released, which flags for the first time that its intention is to ultimately impose greenhouse gas emission limits on licences, which in New South Wales is a seriously major development if they do finally do that. So that's quite a significant case within New South Wales. Next. Now, this is an interesting challenge in the context of water management. I think you can make it out, but you'll see in that smaller picture within the larger picture, that is a picture of the Murray-Darling Basin in Australia. So about nearly a third of Australia goes through the Murray-Darling Basin. So it starts in southern Queensland, goes through most of New South Wales, a fair amount of Victoria, and ends up in South Australia. And so that means that water management across all those areas, there's a very complicated system involving the Commonwealth government and all those states to try and manage the water. So within the basin, there are water sharing plans for the different regions so that all the people who need water, and that could include towns for drinking water, farmers for their stock, miners for their mines, irrigators for their crops, all have to be compliant within this water sharing plan. So they're very important. So the Nature Conservation Council, which is a group in New South Wales, it's the main conservation protection group in New South Wales, has taken action and against the Minister for Water in making a sharing plan for what's called the Borders Rivers region, which is highlighted on that PowerPoint. So the chief ground that they're arguing is that the minister didn't adequately consider climate change or made a legally unreasonable decision to approve the plan. The case is yet to be heard. It's pending. At the moment, there's evidence being collected. But I think it's an interesting case to watch because it's trying to really highlight that decision-making in all different contexts by government departments and ministers needs to be aware of climate change. And the figures from the Murray-Darling Basin are really to the effect that climate change is already shrinking the amount of water going into the basin. So there's increasingly limited supply. Now, as you can see, we're changing topic again, trying to show you the sort of range of litigation that's happening in the Australian context. So we're now back at the federal government level. So this is a federal court case or a couple of cases. And this is the first case where there was an argument about whether a statutory duty of care is owed by the Australian government. And this was a group of young students were taking this litigation. So as you can see in the PowerPoint, that Ms. Sharma, who was one of the litigants, was so young that she needed a litigation guardian who was standing beside her sister Arthur. So the issue was whether under the national environmental legislation, the Minister for Environment did owe a duty of care to these children to consider the effects of climate change when she was assessing a coal mine expansion. Now, at first instance, after looking exhaustively at the evidence, the judge held that a statutory duty was owed, and that was the first time that decision was made in Australia. The federal government appealed, the Minister for Environment appealed, and that decision was overturned. And there's been no leave to appeal to the High Court. But I think all of these cases are, in a sense, part of a journey of climate litigation in Australia. And it will be interesting to see what further developments occur. And on that note, next. This is a related but different case, and this is a group of Tiwi Islanders represented through Mr. Pabai and Mr. Kabai. Now, the Tiwi Islands are to the north of Australia in the Torres Strait, and they are quite a distinct community and Indigenous group, and they have a very strong cultural connection to land and very strong cultural practices. So they are arguing that the Australian government owes a duty of care, a common law duty of care, because of the way they are suffering the impacts from climate change. And what's happening in the Tiwi Islands is that there is water inundation, and they are quite low-lying. So increasingly the land is being physically inundated, but also the water supplies, the fresh water supplies are being affected. So it's having all sorts of negative impacts on the lifestyle for these traditional owners. So this is pending, and once again, a case to watch. It's been certainly in the wings for a while. So I'm now changing tack completely. I'm going to might move through a couple of these quickly. Yes. Just to make the point that now the sort of, I don't know if it's a frontier, but certainly consumer, corporation and financial laws are now being increasingly used by both a regulator enforcing misleading and deceptive greenwashing claims. There's cases of NGOs, non-government organisations filing complaints. That's the second bullet point there. And a very interesting case has been commenced by the Australasian Centre for Corporate Responsibility against Santos. That's that large gas company that featured earlier. And that is a case that's been closely watched it's really about the claims the company's made and how it's going to reach net zero emissions by 2040. And this corporate responsibility, the Australian Centre for Corporate Responsibility is saying, well, we think you're being misleading and deceptive under our Australian company laws, which mean you cannot be consumer protection laws. You must not be misleading and deceptive. And that has generated a great deal of interest. And there's now a lot of literature now being prepared in Australia related to directors' duties, need to disclose climate risk. And that's beyond the scope of this talk. I'd be here for a long time talking about that, but there's a lot of international development that's affecting national development about directors' duties in that space. And this kind of litigation really will focus the mind of companies. So that's, I haven't put it on the slide, but a lot of those cases were about greenwashing. Can we go back, please? Back once, thank you. So in a consumer law context, you talk about greenwashing, where companies make claims about how green they are being or will be. And the issue is, well, is that really genuine? And I suppose what's motivating these kinds of cases is the idea is the market hopefully will drive companies to be greener and take more climate change effective decisions in their decision making. So basically you want a level playing field, so you don't want genuine green products being undermined by products that are having a greenwashing advertising campaign around them. So that's I guess trying to get that market in a good state to make good decision making is what's driving some of that. Next. So I've headed this corporations law, but actually these cases could also be called green hushing, which is a new term I've recently discovered. But that's really where in this case, I think this is looking at a superannuation account and a bank where they are not properly disclosing the climate risks to their business. So they're hushing what the risk to their business might be. And all three of these matters, which have been viewed with interest in Australia, are in fact settled. There's no judgment in any of these matters because ultimately the applicants in those cases, the plaintiffs, got what they wanted out of the proceedings. So in the first one, it was somebody who had his money with a superannuation account, and he argued that he was unable to make an informed decision about where he should put his money within the account because the superannuation fund wasn't telling him what the climate risks were to his investment. So the case settled because the information was provided. So in the two Abrams matters involving the Commonwealth Bank, in the first one, the bank was, Ms. Abrams, I think, was arguing the bank had not provided adequate reporting of climate change related risks, which would affect the bank's assets. So that settled because the bank provided what that plaintiff sought. And in the second one, Ms. Abrams was seeking information from the bank about how it went about deciding whether it would fund greenhouse gas-intensive fossil fuel projects, and how did that fit in with its environmental and social framework. And she argued that the shareholder disclosure provisions in the corporations law provided that. And I've just realised the PowerPoint hasn't been updated because this matter settled in August, only in August this year, and the bank did provide that information to her. Next. This is probably more of the same, but this time in the financial services context. So I don't think I need to explain too much detail, but financial services providers must not be misleading and deceptive, and that includes if they have investments that will be affected potentially or actually by climate change risk, they need to divulge that. Ultimately, the bank tried to strike out the claim unsuccessfully, and that is also settled also recently. And the Treasury, the Australian Treasury is in fact going to publish something about climate risk in that context. Next. I thought it was also worth mentioning that there is criminal law impacts occurring with tightening of protest control laws in Australian states, often following extensive community protest about climate change. So on the right is protesters which are trying to stop the Carmichael mine. So as I said, the Carmichael mine was that very big mine in Queensland, and Adani is the company developing it, and it has had extensive civil protest against its establishment. So that meant it's in Queensland, and each of the protest laws is done state by state, and several of them now have quite onerous protest laws. So for me, this was an interesting case. So the Queensland District Court was looking at an appeal from the Magistrates Court for somebody who had been part of the mine protest and they'd attached themselves to a mining machinery, which was unlawful. And that was occurred in the context of trying to stop the railway access to the mine. So the magistrate sentenced the protester to 3 months jail, which in Australia would be considered lengthy, and which was suspended for 2 years. And the district court considered that was manifestly excessive or unjust given the nature of the protest, which was interesting that the district court on the appeal took that into account. So that sentence was reduced. Now in this one, Mr. Rolls said that he was also interfering with a rail line related to the Carmichael mine, but he should be dismissed on the basis of the extraordinary emergency defence. And he sought to lead scientific climate change evidence about what was happening globally and how we were all affected. Now, that defence didn't find favour in the Magistrates Court in Queensland, but in some of my reading lately of cases, my eye was caught by some protest in France where protesters actually broke onto the tarmac at Charles de Gaulle Airport in Paris and were, of course, arrested. But interestingly, the French court that heard that appeal did allow that kind of defence in that particular context. So it does seem to vary as to who is taking on board those kinds of arguments. Now, I said originally that the Australian Constitution doesn't have anything about human rights in it, which is the case, but 3 jurisdictions in Australia in the last 8 years have passed human rights statutes or charters. And those states are Queensland, Victoria, and the Australian Capital Territory. So in Queensland, there's been one very interesting case involving a coal mine, and this is in the Land Court of Queensland. So as I've said there, it was Australia's first human rights-based challenge to the approval of a coal mining lease, and it was brought in the Queensland Land Court, relying on the then pretty new Human Rights Act. Was only passed in 2019 in Queensland. So Youth Verdict is a youth group who is very concerned about climate change and also has Indigenous members, First Nations members. So they were arguing under the Act that the application was not compatible with their human rights, including the right to recognition and equality before the law, the right to life and property. And ultimately, that was allowed to be brought forward. The mining company tried to stop them, but that was unsuccessful, and they were allowed to become a party in the proceedings. They participated in the hearing before the Land Court. The Land Court went out on country to hear some of the evidence, which once again I would love to have done. And ultimately the Land Court found the project would unjustifiably limit several of those rights. And the way the Land Court operates, they recommend to the relevant minister in Queensland whether approval should be granted or refused, but the minister generally would follow their advice, and the Land Court said that it would not recommend approval. Now, this is a bit of a change of scene, but the organisers asked me to refer to this, and it is an interesting case. So obviously it's not within Australia, but it's a complaint to the United Nations Human Rights Committee from First Nations groups in Australia. And these are, once again, Torres Strait Islanders. I've already mentioned a couple of cases brought by them because they are so concerned about sea level rise. And that is one of the pictures on the right is one of the many Torres Strait Islands, and you can see how low lying it is. They are extremely vulnerable to sea level rise. So the claim, which has been upheld by the United Nations Human Rights Committee, involved several articles there relating to, I think it was upheld on the basis of the right to a free from arbitrary interference with private life, family and home, and the ability to enjoyment of their culture, because all of those things, as I said before, are being affected by the ingress of water. And of course, I'm not going to read it out, but the evidence was about the extent of the impacts that were being experienced in that area. I better move on. Okay, I'll just like to talk to you very briefly about expert evidence in the Land and Environment Court. That PowerPoint is just to emphasise how much evidence we do have. We have to deal with experts all the time. That's fine. So look, I'll keep talking, but we hear expert reports in all the civil kinds of cases we do and also in criminal. So sort of bread and butter for us is how do we deal with all that expert evidence? And I just wanted to talk briefly about that. Yeah, great. So we have a suite of measures to deal with expert evidence. We require experts to give written reports, they exchange them. This is all before the hearing. Very important to manage things before the hearing. We require the experts to meet without lawyers present. We want them to resolve and narrow issues. Sometimes they do resolve completely the issues between them. And so when you get to court, you already know what the key issues are going to be. And then in the court process, you will explore that. So if you still have issues before you, which you are likely to, we always have concurrent evidence, sometimes called hot tubbing. I prefer to say concurrent evidence, and all the experts are sworn in at the same time. They give evidence together, and there's a very ordered process for how issues are dealt with and also for how cross-examination can occur. But as a judge, I found this very useful mechanism for dealing with expert evidence. So this is a change over the time I've been sitting on the Land and Environment Court. We were one of the early adopters of this kind of process. And it does mean that the experts are more readily able to talk to each other if need be. And I can engage more readily with them together at the same time. It's been a really useful introduction. And also, I guess the benefit also in the Land and Environment Court is the expertise of commissioners and certainly judges over time enables us to be able to test that. So just additional measures was we can basically require what evidence is going to be about in a particular type, and sometimes we can require, if it's necessary, additional expertise to be called by the parties. So moving to the last topic, I just want to make a few comments about scientific evidence in climate change cases, because it can be very challenging when you are addressing a global problem. Every time a bit of carbon or greenhouse gases is put into the air, it really affects everybody. So that's a big challenge for domestic courts to deal with evidence that is global. So the cause of action will, of course, determine the nature of the evidence that's needed in that case. And so one of the challenges is linking evidence of climate change impacts to individual sources of greenhouse gases. So there are issues of causation in that context, and there's quite a lot of litigation around the world grappling with this, with various decisions being made about whether the science really allows you to form any view in a legal context about that. Probably at this stage, the very broad IPCC level scientific modelling, which is getting more and more sophisticated, is being applied increasingly in attribution science context, and I'll speak more about that. But for the moment, causation from point source global greenhouse gas emitting projects it's a hard link to make. But interestingly, if you've got a cause of action which is not requiring that kind of causal connection to be made, for example, the cases I mentioned about statutory duty of care, in those cases, there was no argument about the scientific evidence before the court, because the issue, given that it's pretty much accepted now that dangerous climate change is happening at the international level, it might be that that is just not going to be disputed at the local level in the domestic court. Next. So a high watermark case is the Agenda Foundation case, which if you've been studying climate change law, you're probably very familiar with. So this was a very interesting case. It went through all three levels of the Dutch court successfully. The applicant was successful at every level. So the applicant was alleging that the Dutch government was negligent, was based on a tort claim, and also a breach of European Human Rights Convention. And I guess at each level of the court, there was a different focus, I would say, on these kinds of arguments. But ultimately, the evidence on the risk of climate change harm based on those Intergovernmental Panel on Climate Change reports was not disputed by the government. The issue was whether, in this legal context, the government was liable or not. So it went from the Hague District Court to the Court of Appeal, and ultimately the Supreme Court upheld the decisions of the lower courts and also made further comments about the dangers of climate change and the need for action by not only the Dutch government but all states. So I just thought I'd briefly look at some of the evidence that came forward. So this is the 1994 case, the Greenpeace case. So the evidence at that stage was looking at the United Nations Framework Convention on Climate Change, which the IPCC was really only starting to get its work done. And there was a couple of reports, one at the New South Wales level and one at the Commonwealth level, but they were very general reports at that stage. Next. Leaping forward to 2019 in the Gloucester case, essentially an evidence was given by a globally recognised expert, Dr. Will Stephan, an Earth Systems scientist who's worked in the IPCC. He's globally well known, and he gave evidence on behalf of the objector group who were allowed to join in the proceedings and was uncontested. The mining company wasn't saying that his evidence was wrong or contesting it. And he looked at IPCC reports and various other authoritative authors in his evidence. And as you know, that was taken on board and accepted by the Land and Environment Court. In the Sharma case, the statutory duty of care case that ultimately was unsuccessful, the same Earth Systems scientist once again gave that evidence. And the point I'm making there again is that the Minister for the Environment, the Commonwealth Minister, did not contest it. Next. So in the Parbai case, which is the pending case, the common law duty of care, basically there's going to be similar types of evidence about climate change. And I must say at the moment, I don't know if the Commonwealth will be contesting it, but it would be very difficult for it to do so. Next. So last topic of the subtopic of the last topic is the role of attribution science, and that's dealing with this very nutty problem of causation. So essentially, weather and natural variations of weather have been happening for a long time. And so attribution science is trying to deal with that Signal in noise problem. So is it a normal kind of variation, or is it being enhanced by climate change? And it's a very sophisticated modelling required statistical analysis, but there are now conclusions able to be drawn. Next. So some of the questions that might be asked is the event due to natural climate variation or to climate change? Probably it should say, or whether it is enhanced by climate change. Has climate change affected the magnitude of a class of events? Has climate change affected the frequency of a class of events? And those are the kinds of things that attribution science is increasingly able to answer. And for those of you with an interest, the Sabin Centre has a section, that's the Sabin Centre at Columbia University, has a section specifically on climate science and attribution science. It's interesting, they've got articles explaining it, and they have a hub where work in this area is shown. So there's a lot of focus on it. Next. So this is with an Australian focus. I should have said this is based on a talk by Professor David Carrolley from the CSIRO to my court. So we have regular education sessions, including on climate change issues and anything else that could be relevant to our work. So he gave us a seminar in November 2021, and these are based on his remarks there. So this is in the Australian context. So he said that studies on the attribution of extreme weather and climate events have allowed high confidence conclusions on changes in the likelihood of some classes of events due to climate change. And the wisdom now is that the extreme fires in 2019 and 2020 would have been impossible without climate change. Next. So of course, for lawyers, will attribution science be used in court? And so there's now quite a lot of articles about this. A very useful one was published in 2018 by those authors, identifying the large implications from attribution science, with obvious implications for things like tort claims, negligence, or possibly statutory claims. So it is definitely a watch this space. Next. And you'll be pleased to hear that I think this is essentially the last PowerPoint. But those are a couple of useful references. These are focused on the US. The first one in the Columbia Journal of Environmental Law is a very large and very comprehensive article, which it provides a detailed examination for the potential for attribution science to be used in court in various contexts with a US focus. And a more reader-friendly one is the second article there, the 2021 Environmental Law Reporter article, where similar authors or the same authors provide a sort of more focused, smaller article about the law and science of climate change attribution. So this is definitely a watch this space area. On that note, I'm sorry I have gone a bit over time, and I'm certainly happy to answer questions and very interested in any comments people may have. Thank you.
Right. Thank you very much, Justice Pain, for such insightful presentation on climate change development from Australia. Allow me to take notes, to read my notes on the lecture. I have 4 points that Australia, especially New South Wales, have a specialized environmental court that have procedure that look at the site and have remote hearing, and that court have civil and criminal jurisdiction and various qualification to be commissioner. It's very interesting to be the commissioner, to have such background other than law, and it's also have the authority to be an alternative dispute resolution institution. So for the climate change litigation in Australia is the second to the US now in number of climate cases, according to Sabin and Grantham data. Cases are brought to both in Land and Environment Court and Federal Court. Numerous legal argument is used to bring justice to climate, such as review and planning context, mitigation greenhouse gases, and it could be traced back to 1994 and acknowledged to be the first cases not only in Australia but also in the world. It disputes a grant consent to coal-fired power stations and adaptation to climate change, culmination of surrogates permitting judicial review and civil enforcement in other contexts, judges, environmental regulators challenge the water sharing plans, statutory duty of care out by Australian government, for example, the Sarma case, and common law duty of care out by Australian government, such as Torres Strait, is very introduced cases right now, and consumer protection on greenwashing, corporation, financial law. It's also have climate aspects on that being brought to the court in terms of climate cases, and it's also brought in human rights argument and tightening of protest control laws, and it's especially concerning as well as Indonesia, because some activists are bring to the court because of their activisms and their participations to protecting the environment. So and for the expert evidence it is acknowledged as the evidence in several procedural rules, and it could be brought to the court by written or oral, and they have a joint conferencing and allowed to have cross-examination between parties, and various scientific evidence has been presented and allowed in the court, in the Australian court, and causation from point source used to be challenged in court, but nowadays attribution science is used in the court with sophisticated modeling. So everyone, now come to the questions and answer sessions. In the first session, I would like to have 3 questions from the participants. Please raise your hands. See 2.
Okay. Good morning, ma'am. I'm Amanda, and I'm currently studying here too in environmental law. I'd just like to ask, I mean, in a way, we are similar because we do have also a lot of indigenous communities and tribes that are also islanders and are highly impacted by the climate situation right now, as in the sea rise level and all that stuff. But you've mentioned that there has been a rise in cases from indigenous tribes and islanders, and it's like something that we Indonesians look forward to, because our indigenous tribes have also raised questions but have not had the chances to file such lawsuits. I'd just like to ask the more on the process of it in Australia in general. Like, do they the recognition of the indigenous tribes and communities, and if they were to file a lawsuit, how, like, do they have to be recognized first, and like who would they be like assisted by someone from the government or something like that? Thank you.
You want to answer the question? Yes.
A lot of remote First Nations people do live on land that they are recognised to have, so they don't really have to prove it to anybody. They have some resources. They have there's an Aboriginal legal service. I frankly don't know, for the cases I told you, who their lawyers are. They are pretty sophisticated cases, so I suspect they have maybe pro bono lawyers, potentially. They're very cutting edge cases, so there might be lawyers, very competent lawyers, who are keen to take them on. So I'm guessing, but maybe pro bono lawyers. The government won't be assisting them. And so, but, you know, there's access to the court is available. It's not hard legally to get to court potentially, but it practically costs may be an issue. But those communities, I think, would be finding help from the legal profession in taking the cases. And also, it's interesting, in terms of the Human Rights Committee complaint, Indigenous people in Australia are actually fairly expert at doing that. They have a presence in Geneva. I think they have a visiting right, Indigenous organisations. So they're fairly sophisticated in using that, probably more sophisticated than anybody else in Australia. And that's no doubt why that complaint was taken. But that mechanism is available. I'm not sure if you're supposed to exhaust domestic remedies but arguably in Australia, you would say there aren't any. So it might be easier. We don't have any constitutional human rights federally. So if there's no mechanism in Australia, it might be easier to take the complaint. I'm not sure if a lot more constitutions have rights in them now than Australia.
Thank you. Yeah.
Okay, thank you so much for the opportunity. My name is Zefania. First of all, I would like to comment on your honor's extensive presentation. I would like to ask a question regarding the climate change litigation in Australia, if I'm allowed, specifically in the context of greenwashing practices in Australia. Currently, in filing lawsuits, consumer and corporation law are used in litigation to tackle the certain issue of greenwashing. Are there further developments in Australia tackling the practice of greenwashing? For example, the development of acts or regulation, particularly stating about environmental claims. Thank you.
So far, there haven't been, the regulator in Australia, the national regulator of companies, is very interested in stamping out greenwashing. So it actually has issued policies about it, how to, don't do it. And we will do something, we will regulate you if you do it. So there is quite a regulatory focus now in Australia on that. Separately to that, industry bodies in Australia will tell their own members, don't do it. And I do have a longer talk that I gave at this conference about all that. A lot of it's being driven by international development. So the Paris Agreement in 2015, businesses were very engaged in that process, and several committees and expert groups were set up following that about how to encourage business to do the right thing in terms of climate risk mitigation. So a lot of those directives include things like greenwashing, must disclose climate risk. So trying to stamp out greenwashing and green hushing, that is being used now by national regulators, not just in Australia, but it's also being used by industry groups. So if you're being a responsible company, which hopefully you are, you don't want other companies greenwashing and green hushing. So I think there's a couple of movements to try and manage it. It's the regulator, civil society and NGOs are taking action, but also industry itself, I think, is also trying to have its members do the right thing as well.
Okay. Oh, we still have time to have another questions. Anyone?
Thank you for the opportunity to ask questions. My name is Farhan. So I have questions regarding, based on my own research, I have learned that currently Australia having a reform in EPBC Act, where I think it's very one law that really need to be addressed, especially in the issues of climate change currently right now. So one questions that I have in my mind regarding to that is, how does the EPBC Act reform that currently ongoing in Australia will address the challenges posed by climate change? Especially you mentioned about several issues of climate change before in your presentations, and how will this EPBC Act reform will also address the issue of climate litigations and the protections of the World Heritage Sites in New South Wales, because you mentioned that you are one of the judges in the New South Wales region, and I see that there are some critics regarding the EPBC Act, because even until now, it's still not including the climate trigger scheme, because I think it's a very important procedure to be implemented, especially in the climate litigations, because climate trigger can address the rising issue and concern in climate change effects on several environmental areas in Australia?
Yes, the main national act, which is the Environment Protection Biodiversity Conservation Act at the national level, and that carves out a limited role for the Commonwealth. And as that question suggests, it is at the moment being looked at for reform. There's a lot of action by civil society, bodies like the Environmental Defenders Office, which is a community legal centre that does public interest environmental litigation, would be arguing strongly that there be a climate change trigger so that the Commonwealth would become more involved in impact assessment of greenhouse gas intensive approvals, more so than it does now. I don't know if that's going to happen. It's literally in the process now, but there's certainly a strong demand for that change to be made. So one of the triggers at the moment is World Heritage impacts. So one of the ways the Commonwealth Government gets constitutional power is through its engagement with international treaties. So we are a signatory of the World Heritage Convention, and we've actually used that convention a lot to have sites placed on it, and the federal government will involve itself in decisions about that. But one of the challenging areas for Australia is, for example, the Great Barrier Reef, which runs down pretty much the whole of the Queensland coast. It's an absolute global treasure, and it's being very affected by warming sea temperatures, as I said. And so how to address that is very challenging. I can't really give you an answer because nobody knows yet what's going to happen, but certainly there's a lot of discussion in the way you're mentioning.
Another question. Okay, it might be the last questions we have today. Oh, another one here. Okay. Two questions, two more questions.
Okay, first of all, thank you for your time and presentation. I have a question. Do you have anti-strategic litigation against public participation mechanism in Australia to protect the environment human rights defender? Do you catch my question? Do you have anti-strategic litigation against? Yes.
SLAP suits in Australia tend to be defamation actions. So we have quite difficult defamation laws. So there are a couple of examples of community activists being sued for defamation by the proponent for development, the development company. That's the most common way. And it's very expensive to defend the proceedings, and they're very technical. So it is quite can be very unpleasant mechanism. That's the main one. And I can't really compare us to other jurisdictions in terms of how much SLAP suits are stopping people. I don't think they're stopping people, but I think people have to be very careful how they express themselves.
Okay, another question from here.
I have a question. Thank you for the opportunity. I want to ask about the attribution science. So there's a lot of claims that we suffer from an extreme weather due to climate change and attributed to climate change and causing illness and several other things. So if the plaintiff wants to sue the defendant, what should be established so that they have a standing before the court in relation to attribution science? Because in Indonesia, in a few cases I found, the judges usually resort to precautionary principle. What do you think about this? Do you think that this will how to avoid the risk of judicial overreach by using precautionary principle too often?
Is that judicial overreach? I said, is that judicial overreach to use the precautionary principle? I would say not. So in my court, we also look at the precautionary principle. It's part of the fundamental principles we look at. So I probably don't agree with the description of overreach. I was trying to emphasize with attribution science, it's still developing. So the attribution science is getting to the stage where it can say this kind of weather pattern is being exacerbated. Those fires were worse than they might have otherwise been. But to really then come to a court case and prove something is a whole different dimension to expect from the science. So that's yet to emerge, really. I think it's coming, but we're just in this process of how, once again, do you make that broad, agreed, global science effective at a local level? It's a big ask for the science in a legal context. So I think the precautionary principle will be alive and well for a little while.
Okay, I think we have questions from the Zoom. Can we allow him or her to speak?
Yeah. Can you hear my voice clearly? I'm sorry, but I'm unable to at least to start my video, and perhaps I would just like to say it in, perhaps if you can hear my voice clearly, I would like to.
Yes, it's
okay.
Crystal clear here.
Okay, thank you very much. Yeah, thank you, Justice Pain, for your presentation. And for now, I've been assisting a research collaboration between the Faculty of Law, University of Brawijaya here in Malang, collaborated with Thomas More Law School, ACU, Australian Catholic University, about climate change, which subject of our research is Indigenous people, women, and also disability people with disability. And my question perhaps is just once. I prepared two questions, but I think the first questions you answered already. But my second question is about climate clause in your constitution or in the Australian constitutions, whether it is enough. If I'm not mistaken, that I read in the internet that Australia has already have a Climate Change Act that enacted in 2022, if I'm not mistaken, once again. But what I want to ask you, whether it is sufficient to combat the climate change or to act against climate change just through the Climate Change Act, or whether we have, or Australian have to enact a climate clause, or do you have a climate clause in your constitutions or in the Australian constitution? Perhaps that my questions to Justice Pain. Thank you very much.
There is no reference to climate change in the Australian Constitution. In 1901, nobody thought about the environment or human rights, and certainly not climate change. And it's very difficult to change the Australian Constitution. We had a referendum 3 weeks ago trying to introduce a voice for First Nations people, and it was voted no, which is, I think, a blow for many in Australia. So short answer is there won't be anything in the Constitution about climate change. There is a Climate Change Act at the federal level, national level, which is setting up policies and processes to put in train climate change measures. But I guess you need legal responses at all levels. So you need state law that is looking at planning matters, you need state government level policies, and you need federal government policies. And there's a big debate about whether enough is happening fast enough. Everybody has to move to a renewable energy transition, go through a renewable energy transition process, and Australia, like many countries now, is grappling with that challenge. So some of it's answered by law, some of it's answered by policy, some of it is very much economically driven as to whether we can make those substantial society-wide changes that we all need to make. And so hopefully law can contribute to that effort, but I certainly don't think it's the sole answer. Thank you.
All right. Last chance to ask questions to Justice Pain. Oh,
Okay. Thank you for your wonderful presentation, Justice Pain, I would like to ask the difference between magistrate, judge, and commissioner in the term of their duty, because from your presentation, I could see that all of them could give verdict to whether accept or decline the consent that being given. Thank you, Justice Pain.
So I think I've been asked the difference in roles between judges and commissioners. And so the commissioners hear a lot of the project approval merits review matters because they have that expertise I mentioned. If something has a strong legal component or is particularly complex, then a judge would sit with a commissioner to hear those. But when the commissioner sits, they can reject the proposal or they can give it consent subject to conditions, and their merit review stands. You can only appeal to a judge of the court if there is an error of law by them. So it's a very important role that they fulfill. And judges do what judges do in lots of courts, which is hear judicial review, do civil enforcement, and hear criminal matters.
I think there's the last questions we have both in the room and the online participants. So with that, thank you very much, Justice Pain, to be here and sharing your experience and knowledge, of course, on the climate change litigation and the development in Australia. So before we close the lecture, we have a souvenir from Faculty of Law Universitas Indonesia that is delivered by who? Okay, by Ali. And I give back the floor to the MC.
Thank you very much.
Okay. Thank you.
Yeah. Yeah, perfect. You don't have to quit market.
Dengar aja. Oke, mungkin teman-teman boleh kumpul di tengah aja biar bisa dokumentasi.
Is this pen, please here? Yeah, so we have here.
Oke, mungkin teman-teman yang ada di Zoom juga boleh on cam nih, dan juga biar bisa sesi dokumentasi bareng. Thank you. Oke. Oke, sesi dokumentasi dimulai dalam 1. Oke. Kayaknya sini aja. Geser ke kiri aja, jadi kanannya biar nggak tahu. Masih kosong.
Oh, masih kosong.
Iya. Ke depan ibu gue. Udah aman? Oke. Dokumentasi dimulai dalam 1, 2, 3. Lagi. 1, 2, 3. Sekali lagi. Dengan 3 ya. Oke. 1, 2, 3. Oke. Terima kasih teman-teman. Oke. Oke. Okay. Thank you to the documentation committee and the fellow participant. With the joint documentation session, we have finally come to an end of today's event. On behalf of the committee, I would like to express my deepest gratitude, especially to Your Honor Justice Nicola Pain and Mrs. Marcia for sharing their insight, stories, and experience with all of us today. Our deepest gratitude also goes to Bapak, Ibu, Abang, Mbak, and friends of the audience who have participated and become active during the series of events. Hopefully, the knowledge that have been obtained today can be useful for lecture life and work life. On behalf of the committee, I would like also to apologize if there's any mistakes or shortcomings in organizing today's event. And finally, I, Edmund Wang Triputra, would like to say goodbye. Wassalamualaikum warahmatullahi wabarakatuh. Namo Buddhaya, Om Shanti Shanti Om, salam kebajikan, dan good afternoon.